Let's move on because we've got quite a few questions still to try and get through. The next one's from Helen Pringle.
Thank you. The Racial Discrimination Act in Australia makes discrimination unlawful, including behaviour that is discriminates through being offensive or insulting, humiliating or intimidating on the basis of race, colour or ethnic origin. Surveys and submissions to the last occasion when this was an issue in Australia show that a large and solid majority of Australians support the law and do not believe that offending or humiliating others, their fellow citizens, on the basis of race should be lawful. So I'm curious as to why there is a top-down effort by senators, including Senator Abetz, who are working to abolish this section against discrimination when their efforts have so little support amongst Australians of goodwill.
Yeah, we have to try and keep our answers brief because we've got a few things to get through, but Eric Abetz will start with you.
The Galaxy poll, News poll, Essential Research, they've all indicated that people are of the view that the words offend and insult should be removed from Section 18C of the Racial Discrimination Act. I fully support that. Indeed, Professor Triggs in recent times has even indicated that she would want Section 18C, if I understand her correctly, to be replaced with a lot stronger term, namely vilify or vilification. So what we want to do is ensure that we have freedom of speech. So you don't have a cartoonist like Bill Leak being dragged before the Human Rights Commission or half a dozen students from QUT being dragged before the Human Rights Commission to try to justify quite innocuous Facebook posts such as fighting segregation with segregation, that those sort of comments should be deemed as falling foul of the law indicates there's a problem.
Let's go, our questioner wants to jump back in, so I'll just quickly go back to Helen.
May I make a comment that the section in the Racial Discrimination Act doesn't mention speech? It's the section about behaviour that acts in certain ways. And those polls that you mentioned, there are many other polls, and the bulk of the submissions, as I mentioned, which show that you're really traducing Australians and calling them racist when they're not, by saying that they support this.
Well, look, they are not racist. If you support freedom of speech, and it's this sort of name-calling that I just think is not helpful in the public debate, and that is where Tony Abbott recently called the US election the revenge of the deplorables, that if you want to have a debate in this country, sadly, you get labelled as a bigot, as a homophobe, as a racist, and you cannot engage on the issue of freedom of speech. How much robustness do you allow before the law intervenes? And I would have thought Bill Leak should have been allowed to have his cartoon, the QUT students should have been allowed to do what they did, and indeed that is ultimately what the court determined.
Well, come on,
it is interesting, isn't it, that it was a Federal Indigenous Affairs Minister who found Bill Leak's cartoon to be offensive as well. So it wasn't only in the anti-discrimination sector.
No, but see, there's a difference. Just because you find something offensive or insulting doesn't mean that it should be illegal, and you then have to go through a process which indeed Section 18D of the Racial Discrimination Act gives a complete exemption to cartoonists and artists.
Right.
So
let's hear some sharp. You want to jump in, Terri?
I really do. The lack of facts in this debate drives me bananas, right? So no court found that any of the people that you've mentioned have done anything illegal. So the law doesn't have the effect that you think it has. It just doesn't. The fact is we have a Human Rights Commission process of conciliation. They don't make orders, they don't make findings, they don't find that any of the QUT students have done anything wrong or that Bill Leak has done anything wrong. It's a process aimed at getting people together to talk things through so they can try to avoid going to court. And then when they do get to court, the real problem in the QUT students' case, it took the judge from the 11th of March, when the strikeout application was made, till the 28th of October to determine the strikeout application. Now, that's a problem with resourcing of the court, Senator. That is not anything to do with Section 18C. And if you thought that if every time someone brought a claim in contract law or tort law that you thought were misconceived or was trivial, that we should just abolish those causes of action for tort and contract, that would be crazy. And it's equally crazy to say that just because you don't like some of the claims that have been brought under a provision, that the whole provision should be changed. I don't want to see any change to it. I also want to say the word offend appears in the definition of sexual harassment. Are we next going to see an attempt to water down the definition of sexual harassment in the Commonwealth laws? I certainly hope not. But what I really hope out of this is that we stop seeing this martyrdom of people like Bill Leak, whose cartoon was racist. It was a racist cartoon.
Wasn't.
Let's just say what it is.
It wasn't.
Nigel Scullion said it was racist.
Students,
But the process...
And I noticed that when people talk about those QUT students, they never mention the fact that one of them was alleged to have used the N-word. I'm not going to say it, the N-word in one of those Facebook posts. This is the situation. And we never found out because it wasn't determined.
Yeah, but
we
he
never
said that
found
was
out.
not
Well, he
him.
would
But you're
say that,
presuming
wouldn't
his
he?
guilt.
Stick with it.
You're presuming his guilt on
presuming-
national television, and there's no evidence against him.
I'm saying this is what the allegations were.
That is a
and the
racist
matters
smear
were
in
not
itself.
determined.
Tony, can we hear from
You
the
have
racial
smeared
minority,
people.
Not
please?
smearing anything.
You've smeared Bill Leak, who's certainly not a racist.
No, I'm
Let me
saying
tell
the
you, Bill
cartoon
Leak
was a
is no racist.
cartoon.
That is a disgraceful...
I've never met Bill
Your
Leak.
diatribe
That
is
cartoon.
disgraceful. You've smeared this
I know how the
QUT
law
student
works.
who
I know how the
has
commission
no evidence
works,
against him.
and I'm sick of the fact-free
This is
zone in
badly,
this debate.
this is
This
badly
debate is
drafted.
just all
This is
about
badly
virtue
drafted
signaling to their
legislation.
Okay, hang on, guys, you're talking over each other.
Okay, let me say this.
But before you do that, and I'll come back to you quickly.
Tony,
But first of all, I'd like to hear from Nakia, who might have an opinion.
Yes, I have an opinion, but I also have some numbers.
Totally.
Right, okay, I'm just going to wait for you two to stop bickering.
Guys.
Thank you. Okay, so...
Did you, so just very briefly before you do that, do you have any view on the Bill Leak cartoon?
Oh, I think it's racist. As an Aboriginal person, I think it's very, very racist. Very, 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 very racist. Yes, I know you don't think so, Eric, but I do have some numbers. I did a little bit of research. I wrote it down because I'm an actor and a writer. This is not my forte. There were 2,388 complaints to the Australian Human Rights Commission last year in regards to complaints made under the Racial Discrimination Act. Now, that's not limited to Section 18C. That's just under the Racial Discrimination Act. There's 23.13 million people in Australia. That's a 0.01%. 90% of those complaints got solved at the Australian Human Rights Commission level. 10% of those complaints didn't. That's not saying that it goes on to the court, to an adversarial process. That's just saying it didn't get solved at the Australian Human Rights Commission level. So what we're saying is we're looking at changing an entire law for less than 0.001%. So to say that this is a question, this is an issue that affects the majority of Australians, to say that this is something that is on the tips of the tongues of every single Australian in the polls that you're mentioning is not correct. What we have is a bunch of elite politicians abusing their power and wasting funds on their personal pursuits and their own agendas that are not a public matter, nor are they in the public interest. And we're paying a senator $195,000 a year on an issue that affects 0.001% of Australians.
Okay, now... Ben wanted to jump in and then I'll come quickly.
Look, I'm with Nick here on this. The whole discussion and debate around 18C has never been about ordinary Australians' access to freedom of speech. It's about powerful individuals and powerful organisations having an angry circle jerk about how horrible it is to be called out to be racist in a public forum. In all of this conversation, we are not having a conversation about Section 18D, which follows immediately after Section 18C, surprisingly enough. And Section 18C gives you wide berth. It is like the biggest caveat to 18C possible. You can insult people if it's part of a discussion or a debate, like this one. You can offend people if it's for genuine purpose in the public interest. You are free to humiliate whoever you want if you're making fair comment based on a genuine belief. With all that written down as the section that follows 18C, what liberties to freedom of speech are we not having access to in all of this?
Now, Ben, we're nearly out of time, so come to your point quickly.
Okay, here's a point. Hands up how many of you identify as a racial minority in this country. Keep your hand up if you have experienced racist abuse in this country. That's the issue.
Erica Betts.
The process is the punishment, and if what you say about Section 18D is correct, then why did the Race Discrimination Commissioner seek somebody to complain about the Bill Leak cartoon if he should have known, on your interpretation of the law, that that was completely excusable. And that is where the process is the punishment, and with all the cases that are conciliated, what happens is people don't have the money to afford lawyers to go to the federal court, so they pay what's called the go-away money, the $3,000, $4,000, $5,000, like 3 of the QUT students did, so they wouldn't have to go to
OK,
court.
now
The other 3 went ahead and
we're
won.
pretty much out of time, and Greg Sheridan desperately wants to get...
I want to say 3 real quick things. Bill Leak is a magnificent guy. There's not a racist bone in his body. That was not a racist cartoon. Even if you think it was, it certainly shouldn't be illegal.
As an Aboriginal person, I'm interrupting you, Greg, I do think it was racist. So as an Aboriginal person, please do not make that general statement that it wasn't. As a white man, you think it wasn't. So good for you.
But also the Indigenous Affairs Minister, Nigel Scully,
I'm going to get my 3 quick points, all right? The second point is, this is very badly drafted legislation. No similar Western country has legislation like this. The definition, the more you have windy, vague words like offend and all the rest of it, the more you leave law in the hand of judges, and everyone recognises that it's badly drafted legislation, including the Human Rights Commissioner.
Third point.
And the third point is, I am ashamed of Terry. I am ashamed of you for defaming that QUT student. You said he used the N-word, and then when Eric said he never used the N-word, you said, well, he would say that, wouldn't he? Here you go on national television attributing guilt to a completely innocent QUT student whose life has been buggered up by this ridiculous legislation. Freedom of speech is an important principle for everybody, and we're all allowed to have an opinion on it.
Now,
And this doesn't encumber freedom of speech. 18C, this needs to move away from being a discussion about freedom of speech. This isn't a discussion about freedom of speech. This is the right for people to be protected from being harassed, intimidated, bullied because of their race, because of their sex. It's... OK, well, it is. That's what 18C is there is for. It's to protect those who are vulnerable. It's to protect, it's not just the Aboriginal community. It is the Jewish community. It's the refugee community. It is women. It is people who are trans. It is people of different sexes. It is a whole array of people. So we need to stop talking about it being free speech. It's actually protecting the marginalised. There's a reason that this law was put in place, and it's for equality and protection. And do we really want to be the country that allows there to be religious persecution?
And that is where we'll have to leave it. That's all we have time for tonight. Please thank our panel, Benjamin Law, Erica Betts, Nakia Louie, Greg Sheridan and Terri Butler. Thank you.